When I stepped out my back door that Monday morning, coffee in hand, I nearly dropped the mug. There it was sitting right in the middle of my yard, a half-built clubhouse. I blinked, then I blinked again. No, I wasn't hallucinating. Some idiot had actually poured concrete, set up framing, and started construction on my land. I'm Vance, a 39-year-old electrician who owns every square foot of my property, legally surveyed and recorded when I bought the place 3 years ago. So imagine my shock when I walked around the structure and found a plastic sign staked in the dirt. Future site of Maple Glen HOA Community Clubhouse ESD, by board approval, my ass. Nobody asked me. And the best part? The building sat 20 feet deep into my backyard. I stormed over to the HOA office, which, of course, was inside a converted garage on the other side of the neighborhood. And who do I find there? The queen of complaints herself, Charlene Applegate, the HOA president, a woman who once fined me $200 because my trash bins were out 3 minutes before the approved time. She looked up from her desk like I was interrupting a royal audience. "Yarden, you can't just barge in here like this. They're building a clubhouse on my land," I said, slamming the sign down on her desk. "You want to explain that?" Charlene blinked, then gave this stiff little laugh like I was being dramatic. "The board approved construction months ago. It's part of the community improvement plan." "Then the board approved trespassing?" I leaned in. "That land is mine. My property line starts at the back fence and runs 20 feet north. I've got the survey and deeds to prove it." She waved her hand like I'd brought her a coupon for expired milk. "Yarden, don't be difficult. That strip of land has always been open and unused. The community needs this clubhouse. It's for everyone. You didn't even ask. You would have said no, and that makes this okay? Look, it's already under construction. Might as well let them finish. You'll still have plenty of yard left." I stared at her, stunned. She actually thought I was going to just let it slide. "You tell your crew if they set one more brick on my land, I'll have them charged with trespassing. And if that building's not gone in a week, I'll tear it down myself." Charlene's smile vanished. "You touch that building and we'll sue you for destruction of HOA property." I didn't respond. I just walked out, already dialing my lawyer. Turns out I was right. The land was mine fully and legally. The HOA had no easement, no approval, no right-of-way, not even an email to me. It was an illegal build, plain and simple. But instead of getting them to stop construction, my lawyer suggested I let them finish. He leaned over his desk, grinning. "Let them build it, then rent it out. It's on your land. They built on it without permission. That structure belongs to you." By the end of the week, the walls were up, the roof was on, and the crew left. No ribbon-cutting ceremony, no announcement. They just assumed I'd give up. I didn't. I rented it out. Weddings, baby showers, retirement parties, even a dog fashion show. Every weekend, that place was packed, and every dollar, straight into my pocket. Charlene found out when she drove by and saw a taco truck parked out front, music blasting, and a bachelorette party dancing on the porch. She slammed on the brakes, marched across my lawn in her kitten heels, and jabbed her finger in my face. "You're running an unapproved business on HOA land," she screeched. I sipped my iced tea. "It's not HOA land, remember, it's mine. And thanks for the free clubhouse." Her face turned the color of boiled shrimp. "You'll regret this, Yarden. The board will not stand for this," I grinned. "They'll have to stand on the sidewalk then. Because the board's not welcome on my property." I turned and walked back into my house, leaving her shrieking to no one. This was just the beginning. By the following Wednesday, I had a waitlist 3 pages long. People were practically begging to book events in what the neighborhood was now calling Club Vance. The irony wasn't lost on me. Charlene's vanity project had become the most popular spot in Maple Glen, and not a dime was going to the HOA. I kept everything above board: permits filed, noise ordinances respected, taxes paid. I wasn't about to give them any ammunition. And I had cameras, plenty of them, every angle covered. I installed them the same day I found a strange man with a clipboard wandering the property, pretending to be checking the gutters. He left the second I asked for ID. That weekend, I hosted a retirement party for a local firefighter. About 30 people showed up, catered barbecue, string lights, even a live jazz trio. Around 9, a patrol car rolled up. Officer Cormier, whom I'd known since high school, stepped out, looking slightly annoyed. "Got a noise complaint," he said, eyeing the crowd. "Funny," I said, motioning to the decibel meter I'd mounted near the porch. "We're under the city limit." He checked it, then looked over at the party. "Looks like you're good. Mind if I use the bathroom, though? Traffic on the way here was brutal." I waved him in. Charlene must have made the call. She was losing ground and badly. But I knew she wouldn't quit. People like her never did. Sure enough, the next morning I received an envelope taped to my front door, not postmarked, no stamp. Just my name in shaky cursive and a stack of papers inside cease and desist, written on Maple Glen HOA letterhead. They claimed I was operating a commercial enterprise on association land without board approval. I took the papers straight to my attorney. "These aren't worth the toner they're printed with," he said, flipping through them. "They're trying to bluff. They know they don't own the land, but they're hoping you don't fight it." "They're bluffing me with my own clubhouse," I said. "Impressive," he nodded slowly. "Keep documenting everything. If they escalate, we go public." Escalate they did. The following week, I noticed a new addition to the clubhouse, an electrical panel that hadn't been there before. I hadn't installed it. I opened the cabinet and saw wires running from it into the building and then underground. Someone had tampered with the electrical system. I shut off the power and called in a favor my buddy Tom, a city inspector. He came by that afternoon and took one look before whistling low. "Someone tried to piggyback off your line. Sloppy job, too. This could have started a fire." He took photos, filed a report, and promised to notify the city. That night, I reviewed my security footage. Just after midnight, 2 men wearing reflective vests let themselves in through the back gate. One was clearly talking on a walkie. I zoomed in. The HOA's logo was stitched onto his jacket. I sent the footage to Tom and CC'd my lawyer. By morning, the city had opened an investigation. Tampering with electrical systems without a permit. That wasn't just a code violation, it was criminal. Charlene called me at lunchtime. "Yarden, we need to talk." "I'll bet we do." "I had no idea anyone authorized that work. I'm just as shocked as you are." "I've got video of your board member unlocking the gate." She paused. "That could have endangered lives," I added. "There were kids at that party 2 nights ago. You want to guess who would have been liable if something went wrong?" "I'm sure this is just a misunderstanding. Let me speak with the board and get back to you." "Do that. And tell them the city inspector's already involved." I hung up before she could spin another excuse. That week, I noticed fewer passive-aggressive notes appearing on community bulletin boards. Even the usual HOA enforcers, the ones who used to walk around with clipboards photographing people's lawns, suddenly weren't so visible. Then, it happened. 2 plainclothes officers showed up at the HOA office on Thursday morning. I was on my way to grab groceries when I saw them step inside. 10 minutes later, they walked out with a box of documents and a laptop. The garage door slammed shut behind them. Local news picked up the story that night. Maple Glen HOA under scrutiny for unauthorized construction and utility tampering. They mentioned my property, but I'd requested anonymity. Still, anyone in the community knew whose land it was. Things got real quiet after that. The next board meeting was packed. Neighbors who hadn't attended in years filled every seat, some standing along the walls. I stood in the back, arms crossed, watching the farce unfold. Charlene tried to keep control, banging the gavel like a substitute teacher on her first day, but it was chaos. People demanded to know how the board approved construction without land rights, who authorized the electrical work, and why community funds were being used under the table. A man named Lucas, a retired contractor, stood and read from the HOA's own bylaws. No structure may be erected on any land not explicitly deeded to the association. Violations are subject to legal review and financial restitution. People clapped. Someone shouted, "Resign." Charlene tried to respond, but her voice cracked. "This is all being taken out of context." "Context doesn't change the law," I said, stepping forward. "You trespassed, you built illegally, and you endangered lives. You should be grateful I didn't press charges." The room went silent. Then Lucas turned and addressed the crowd. "I motion to suspend the current board pending legal review and appoint an interim committee." The vote passed. Unanimously, Charlene stood face pale and walked out without a word. The interim committee formed that night. First order of business: reassess all current construction projects and review financial records. Second, offer public apologies to affected homeowners. They asked me if I wanted the HOA to buy the clubhouse from me. I laughed. Why would I sell it? It's the most profitable thing in this neighborhood. Instead, I offered them a deal. I donate the space for one community event each month free of charge as long as they stayed off my property the rest of the time. They accepted. Now, every second Saturday, the neighborhood gathers at Club Vance for potlucks, movie nights, and local fundraisers. No clipboards, no fines. Just people enjoying their neighborhood without fear of petty tyranny. And Charlene. She moved 2 towns over. Word as she tried joining another HOA. They passed. The transition from chaos to calm in Maple Glen didn't happen overnight. Sure, the board was suspended and Charlene had vanished, but the damage she and her cronies caused had deeper roots than anyone realized, roots that were about to get yanked out, one by one. 3 weeks after the interim committee took over, an email landed in my inbox from a name I didn't recognize. Emery Caldwell, a forensic accountant contracted by the new committee. He asked if I'd be willing to meet regarding financial anomalies linked to the illegal clubhouse construction. I agreed. Not out of curiosity, I already knew something shady had been going on, but because I wanted it all dragged into daylight. We met at the local library in a quiet corner room. Emery was in his 50s, a quiet, sharp-eyed man with a voice like gravel and a folder thicker than a phone book. "I'm going to get right to it," he said, laying out photocopies. The HOA board used community reserve funds to pay for the clubhouse, over $80,000. None of it was approved by a member vote, and several disbursements were routed through a shell landscaping company that doesn't actually exist. I scanned the documents. The fake vendor name was Green Core Solutions, with a P.O. box address and a disconnected number. On paper, they'd supposedly done land prep, grading, and utility installation. In reality, they were nothing but a funnel. "Let me guess," I said. "Board member connections," he nodded. "We traced the payments back to a bank account owned by a man named Curtis Applegate." My eyebrows rose. Charlene's husband, ex-husband, divorced 2 years ago, but they still co-own a rental property in town, not exactly strangers. I leaned back, absorbing it. So they not only built on my land without permission, they laundered HOA funds to enrich themselves in the process? Exactly. And that's not all. Emery pulled out another set of forms permits, or rather, the conspicuous absence of them. They filed a falsified zoning application with the town clerk's office, claimed the land was common-use green space. That hit like a punch. Someone had submitted forged municipal documents under my parcel number, trying to reclassify it without my knowledge. That wasn't just fraud. That was felony-level tampering. "Have you gone to law enforcement yet?" He nodded. "The county sheriff's office has opened a formal investigation. A detective may be in touch," and they were. 2 days later, a pair of investigators, Detective Carla Hensley and her partner, a younger guy named Ruben, showed up at my door. They were polite but all business. Hensley flipped open a notebook and got straight to it. "Mr. Vance, we're conducting a criminal inquiry into the falsification of zoning documentation and misuse of HOA reserve funds. We understand you're the legal owner of the land in question. Can you verify this with your deed?" I handed it over. She looked it over, cross-referenced the parcel number, and nodded. "Perfect. Here's the thing," she said. "We've pulled building permit applications from the town archives. Your name's on none of them, but someone used your parcel number and signed using a forged signature." Reuben held up a scanned document. The signature was laughable, nothing like mine, and the listed email was a Gmail account I'd never seen before. "Know this address?" he asked. "Nope." "Never seen it, but I bet if you subpoena the IP logs, you'll find it traces back to someone in Maple Glen." Hensley tucked the paperwork back into her folder. "We're already on it, and Mr. Vance, if you're willing, we'd like you to file a formal complaint." "That strengthens our case, absolutely." Over the next week, the investigation ballooned. Residents started coming forward with stories of suspicious dues increases, unexplained fines, and disappearing maintenance funds. One woman, a retired nurse, tearfully explained how she'd paid a $2,000 roof compliance fee out of pocket, only to learn later that no such rule ever existed. The local news picked it up again, this time with the headline, "Maple Glen HOA under criminal investigation for fraud, forgery, and embezzlement." The reporter even stopped by the clubhouse for background footage. I stood in the doorway behind her, arms folded, as she explained that the structure had become a symbol of resistance against abuse of power. Then came the warrants. Charlene's former home, now a rental, was raided. Curtis Applegate was arrested the following morning at a golf course in the next county over. Footage of him being led away in handcuffs made the evening news. Financial records, laptops, and even old board meeting recordings were seized. By the time the dust settled, the county prosecutor had filed formal charges against both of them: conspiracy to commit fraud, misappropriation of community funds, filing false governmental documents, and criminal trespass. Bail was denied due to flight risk. The new interim committee held a town hall shortly after. Emery was there along with Detective Hensley, who gave a brief but powerful statement. "This investigation is ongoing. If you've experienced any irregularities involving HOA fees, fines, or property violations, now is the time to come forward." And people did, one after another. Turns out the old board had been running a racket for years, padding their own pockets while intimidating anyone who dared question them. But now, nobody was afraid anymore. With the clubhouse firmly under my ownership, confirmed by both civil court and zoning authorities, I decided to take things a step further. I filed a private lawsuit against the HOA for damages related to the illegal construction, unauthorized use of my land, and emotional distress caused by the months of harassment. They settled out of court a month later. The new committee issued a written apology, and I received a check large enough to cover not only all legal costs but a complete renovation of Club Vance. I added a wraparound deck, an industrial-grade kitchen, and solar panels on the roof. The place was now booking out 6 months in advance. But perhaps the most satisfying moment came during the final sentencing hearing. Charlene stood in court, wearing a gray suit and forced neutrality. The judge didn't mince words. "Miss Applegate, you abused a position of trust, manipulated public records, and jeopardized the safety and finances of an entire community. You are hereby sentenced to 4 years in state custody and ordered to pay restitution in the amount of $98,000. She didn't look at anyone as she was led away. Afterward, I stepped outside the courthouse and was greeted by a small crowd of neighbors. People cheered, clapped me on the back, some even hugged me. But it wasn't about me. It was about taking back our homes, our rights, our dignity. One woman, a single mother who'd nearly lost her home over inflated dues, looked at me and said, "You gave us our neighborhood back." I just nodded. No need for speeches. Now, the HOA operates with full transparency. Budgets are posted online, meetings are open and recorded, and every committee member is elected by majority vote. The clubhouse, still affectionately called Club Vance, has become a symbol not just of resistance, but of what happens when people stand up for what's right and refuse to be bullied. And me? I still run the books, maintain the building, and handle the rentals. But I also keep a copy of the original HOA sign, the one they staked in my yard, without permission, framed and mounted above the fireplace inside. A little reminder of what happens when you try to steal from the wrong guy. Exactly 6 months after Charlene's sentencing, I received a letter from the county recorder's office. At first, I assumed it was a confirmation for the zoning updates I'd filed after renovating Club Vance. But when I opened the envelope, I found a certified notice stamped with red ink. Notice of lien dispute. Buried in the legalese was a claim that the HOA, though now under completely new leadership, had discovered a previously unrecorded shared use clause dating back 18 years, allegedly granting the association easement privileges on my back lot. They were claiming that the clubhouse, despite the court rulings, was still subject to community access rights, and that I was violating this clause by renting it out privately. I read it twice, then again. It was complete fiction. That clause didn't exist, not in my deed, not in the HOA's founding charter, not in any public records. I didn't call my lawyer right away. I went to the meeting. The next evening, I walked into the Maple Glen Civic Center where the new committee had been holding open sessions and took a seat in the front row. The room was quieter than it used to be. Less tension, more curiosity. People had started trusting the process again. Clara Morales, the acting chairwoman, spotted me from the table and gave a cautious nod. I raised my hand and spoke without waiting for formalities. I received a lien dispute notice this week. Supposedly, there's an old clause giving the HOA shared access to my property. Anyone here want to explain where that came from? Clara leaned toward the microphone. Mr. Vance, I was notified about that filing this morning. I requested an immediate hold on its processing until we could verify its legitimacy. A man at the far end of the table, someone I hadn't seen before, cleared his throat. I submitted the claim, he said. Name's Elliot Trask. I joined the committee 2 months ago. He wore a crisp beige blazer, too clean for someone who lived here. His voice was practiced, like he'd rehearsed it in a mirror. I came across a scanned document archived in a digital HOA folder labeled Historical Agreements. It wasn't indexed properly, but it clearly references a shared-use corridor stretching along the north boundary of your property. I believed it warranted investigation. I stared at him. You found an unsigned, unrecorded scrap of digital paper and thought it gave you legal grounds to file a lien against my land. Elliot didn't blink. As a committee member, I'm obligated to protect community interests. If there's even a chance, there isn't. I pulled a copy of my title chain from my jacket, complete with survey marks, timestamps, and signatures from every prior owner. This corridor you're referring to, it's not mentioned, not once. Not in the original plat, not in any addendum, not in any transfer. This isn't a dispute, it's a fabrication. Clara stood up. Mr. Trask, did you consult the county archives before filing the lien paperwork? No, Elliot said, shifting slightly. I was told the digital archive was comprehensive. By whom? He paused. A former board member. I didn't get a name. I stepped forward and placed the documents on the table. There's only one reason someone would make up an access clause now. Someone's trying to claw back revenue from the clubhouse, and they're using people like Elliot to do it. Clara looked at the papers, then looked back at him. Effective immediately, the lien filing will be withdrawn. And Mr. Trask, your appointment to the committee is suspended pending review. He opened his mouth to object, but the room was already murmuring. A few people clapped. Someone near the back muttered, "Here we go again." I walked out before Elliot could try to corner me. I didn't need his excuses. What I needed was to find out who had fed him that clause. That night, I pulled up the HOA's old digital archives. Most of the files had been turned over to law enforcement months ago, but a few backup drives had been returned after the initial investigation. I combed through them for hours, cross-referencing every folder. Buried in a subfolder labeled Legacy Notes, I found a PDF scanned from an old notebook page. In shaky handwriting, it read, "Use corridor behind 219B flag for future clubhouse build. Mark as provisional common space." No date. No initials, no signature, no accompanying plat filing. I checked the metadata. The file had been created 2 years ago, long after I'd bought the property, and the user who uploaded it, an account labeled S. Applegate Admin. I forwarded it to Detective Hensley. She got back to me the next day. "Mr. Vance, thank you for that file. We cross-referenced the metadata, and it matches a series of uploads we've already flagged from Charlene's tenure. It appears she created several forged documents and stored them in the digital archive, possibly to create a paper trail if she ever needed to retroactively justify her actions." I asked her what that meant for the current claim. "We're reopening the investigation under a new charge: attempted land title fraud. The individual who filed the lien may be questioned as a witness or potentially as an accessory, depending on what we find." Within the week, the lien was rescinded and Elliot resigned for personal reasons. I thought that would be the end of it. It wasn't. The county investigator assigned to the reopened case contacted me a few days later. He'd found a pattern. Charlene and 2 other former board officers had drafted nearly a dozen fake easement claims during their time. Most were never used, but all were stored in digital folders disguised as routine HOA documents. One had even been used to pressure an elderly couple into giving up a patch of land behind their home. They'd assumed it was legitimate and sold it to the HOA for a fraction of its value. The county filed additional charges against Charlene and the 2 former officers: conspiracy to commit real estate fraud and elder financial abuse. At Charlene's second hearing, she looked smaller. Not physically, but spiritually, like someone who no longer believed she could talk her way out of anything. The courtroom was quiet when the judge read the new charges. Her attorney didn't argue. She pled guilty. The judge handed down an additional 2 years, plus full restitution to the couple, who sat quietly in the front row. The woman clutched her husband's hand, and both nodded when I caught their eye. After the hearing, the county posted a public notice. Any homeowner affected by HOA misconduct could petition for review. Several did. A few even sued and won back illegal fines and assessments. As for Club Vance, I made one final change. I partnered with a local nonprofit to offer the space free of charge for veterans support meetings, EMT workshops, and job training events twice a month. It had become more than a venue. It was a place where people could gather without fear of being manipulated, fined, or threatened. One evening, after a community CPR class wrapped up, Clara stopped by with a folder in hand. "We're retiring the old HOA charter," she said. "Too many loopholes, too much baggage." The new charter limits board power, mandates third-party audits, and requires member majority approval for any spending over $500. She handed me a copy. At the bottom, in bold, was a clause I hadn't expected. "No HOA officer may initiate legal action against a homeowner without full board review and member vote." I nodded. "That'll keep the next Charlene from trying anything." She smiled. We also added a clause: "No construction of any kind on private property without notarized consent." Smart. As the sun dipped behind the trees, neighbors began arriving for the monthly community dinner. Lawn chairs unfolded, kids chased each other between tables, and someone lit the fire pit. The clubhouse lights cast a warm glow over the yard. I stood on the porch and took it all in. Justice had been served. The corruption rooted out. The community healed. And every time someone stepped into Club Vance, they were stepping into a story, a reminder of what happens when one person stands up, refuses to bend, and turns a land grab into